welcome again to this series of lectures on reservation in services for scheduled caste, scheduled tribe, OBC and EWS in the government job. In this series, we will be trying to comprehensively cover all the aspects of reservation in government jobs. Let me very quickly give you an overview of what we will be covering in various small videos that we'll be bringing out shortly. In today's lecture, we'll talk about the provisions in our constitution. We'll specifically talk about Article 14, Article 16, Article 335, which is regarding reservation in services. Then we'll talk about in the subsequent videos the scope and applicability of reservation. That is where reservation is applicable, which are the posts which are exempted, which are the areas in government jobs which are exempted from reservation, and where it is applicable, what is the quantum of reservation. Then very important topic is caste certificates. To get the benefit of reservation, a candidate must possess a certificate. We will see who can issue the certificates, because we know not everybody can issue a certificate. Only revenue authorities are entitled to issue certificates. Why? What should it contain? We will also see the effect of migration. When a scheduled caste, scheduled tribe for one state migrates to another state, whether he is entitled to benefit of reservation in the state government jobs to the state he has migrated. What happens when a scheduled caste boy marries a non-scheduled caste girl, or a scheduled caste girl marries a non-scheduled caste boy? We will also see the effect of conversion on the status of caste. Another very important topic we will try to deal in this series will be various concessions and relaxations available to scheduled caste, scheduled tribe, OBC candidates for government jobs. We will try to understand the core of reservation. The heart and soul of reservation is actually rosters. So we will try to understand what is the difference between the post-based rosters which we are implementing today, and why the vacancy-based system has been held as wrong by the various courts. So we'll try to understand the difference between post-based and vacancy-based. Then we'll apply reservation in direct recruitment. We will try to understand the concept of own merit, then preparation of panel of the candidates, how candidates are selected, what is the meaning of scheduled caste, scheduled tribe, own merit. The same concept we will apply in promotion, and then the monitoring mechanisms, which are National Commission for Scheduled Caste, National Commission for Scheduled Tribe, the other important officer in the government system to ensure that the reservation policies are implemented properly, that is liaison officer. Let us immediately try to go to the first topic and come to Article 14. Article 14 of the Constitution, Article 14 talks about equality. So it says, the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. In other words, it says that everybody will be same in the eyes of the law. There will be no discrimination. So the basic idea of equality emanates from Article 14, and it is one of the basic features of the Constitution, as has been held in Keshwananda Bharti. One of the basic features of our Constitution is Article 14, and the subsequent articles, Article 15 and Article 16. Article 16 is what we will talk of specifically, are nothing but an extension of this principle of equality. But equality, when we are talking of equality, what is the meaning of equality? Does it mean that everybody will be treated equally? There will be same law for everybody? It does not mean so. Equality does not mean same treatment to everyone, because human beings are not same in every aspect, and therefore treating everybody with the same paintbrush would be not the meaning of equality. Equals must be treated equally and unequals must be treated differently. So the basic concept of equality is that in the eyes of the law everybody is same. But yet we must be aware that human beings are not same in every aspect, and therefore they have to be treated differently. So only equals must be treated equally. जो एक जैसे हैं उनको एक जैसा treat करना है, जो एक जैसे नहीं है उनको हम अगर same standard से treat करेंगे तो inequality बढ़ता चला जाएगा. So if we treat everybody equally with the same standard, with the same law, the inequality will go on increasing. So when the matters have gone to the court interpreting the Article 14 and the meaning of equality, so what has emanated basically over the years is that people are different and they have to be treated differently. You can't treat everybody with same. Now, the application of the principle of equality in real life means we must therefore differentiate between those who are equal and those who are different. So, reasonable classification in laws has been held as valid. So, differentiation between people is right as long as it has got some reasons. And therefore, the courts have held that if you have different laws for different class of people, it is okay provided there is a nexus, there is a relation between the object of the law and the differentiation. So one of the important concept of equality is that a reasonable classification is permissible. Now to understand this, see this photograph. In this there are three boys who are watching a cricket match or a football match, and somebody who doesn't understand equality has given them, each one of them, 3 stools of the same height and asked them to watch the cricket match. Now do you think this boy, who also has been treated equally and has been provided the same height stool, will he be able to ever watch the match? Perhaps no. Because equality means that treat equals equally. Those who are different have to be treated differently. And that is the meaning of equality. So, what will you do to change this to the concept of equality that we have discussed just now? Perhaps this would be the result of equality that we have just now understood. This tall boy does not require this tool. So this boy requires 2 stools. So we have given him 2 stools and this boy has got no stools because he doesn't require one. So treating equally means those who require special benefits must be given those special benefits to get the same opportunity as the other person. So we come to Article 16 directly, having understood the meaning of equality. As I said, Article 16 is an extension or an instance of Article 14. Article 14 was a general law of equality. Article 16 is specific to equality of opportunity in matters of employment, jobs. Clause 1 says there shall be equality of opportunity for all citizens in matter relating to employment or appointment to any office under the state. Now what does it mean? That means it says that a person will get equal opportunity when it comes to jobs under the state. And state means anything which is a government. So bank, Punjab National Bank is a state. Life Insurance Corporation is a state. Of course, government ministries are all state. So anything by and large which is government owned would be state, and therefore when it provides equal opportunity for all citizens in matters relating to employment under the state. So only in government jobs or in PSUs or in autonomous bodies which are under the government, there shall be equality of opportunity. This is a guaranteed fundamental right available to every citizen. Now, since as you have seen that clause 14 permits classification, obviously clause 1, which guarantees equal opportunity for all, also permits classification, reasonable classification. And therefore in the government job you will find that you pick up any rules, any instructions of the government, it will not be equally applicable to everybody in the government in the same way. We have different leave rules, we have the same leave rule for all government servants, but we have some special dispensation for lady government servants. For example, they have a maternity leave of 180 days, whereas the paternity leave for men is only 15 days. This is not discrimination. This is a reasonable classification. Similarly, if you see government jobs, when we apply for any government job, you will find some height has been mentioned. to apply. And you will find that there is some relaxation for those in the northeast and the hilly areas region. So that is again not a discrimination, it is a reasonable classification. Now clause 2 gives an example of clause 1. Clause 1 says there shall be equality opportunity. Clause 2 gives us some examples with illustrations. So it says no citizen shall on grounds only of religion, race, caste, sex, descent, place of birth, residence or any of them be ineligible or discriminated against. So it gives special illustrations that on the basis only of religion or on the basis only of race or on the basis only of caste, there cannot be any discrimination in government jobs. Now, one question which often arises here is, it talks about caste. So it says only on the basis of caste, no discrimination can take place. It needs to be understood that the word only is very, very important here. So what this clause 2 prevents is discrimination only on the basis of caste. It has to be appreciated and understood that in government jobs, we are not reserving seats for anybody only on the basis of caste. All those castes for which we are reserving seats also are, besides belonging to a particular caste, they are also backward socially. And therefore, what clause 2 prevents is only on the basis of caste. So we are not reserving seats for anybody only on the basis of caste. Caste is only an identifying factor to find out in India who is backward. But it is not the sole factor to decide who is backward. Now see this picture again and the meaning of equal opportunity will again be clear. As we discussed in 14, reasonable classification is permitted, but this man doesn't understand and he asks all these probable candidates for a government job. He says that for a fair selection, everybody has to take the same examination. Please climb that tree. Now, if he is asking everybody to climb this tree, obviously most probably this person only will get a job. So this is not understanding equality. Equality says that only equal should be treated equally. Unequal should be treated differently. So you can't ask everybody to pass through this test of climbing tree to get a job. See another. Now everybody is required to ride a bicycle. But if this person is not provided a bicycle with little modification required, then obviously we will be denying equal opportunity to this person, which is a guarantee given under the fundamental right, part 3 of the Constitution. Now this picture is again same as we saw earlier. Now the small girl, if he has to be given the opportunity of reading these books, have to be provided with a longer stool compared to this boy. So that is what is fairness, that is what is equal opportunity means. Now we'll come to clause 4. Clause 4 says nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any backward class of citizen which in the opinion of the state is not adequately represented. So if you see, clause 4 enables the state and it says that nothing in this article shall prevent. That means clause 1 and clause 2, which is talking about equal opportunity, shall not prevent the state from making any provision for the reservation of appointments or posts in favor of any backward class of citizen which in the opinion of the state is not adequately represented. In other words, the state will have to form an opinion that those who belong to backward classes are not adequately represented. So in clause 4 you can see clause 4 is an enabling provision which enables the state to provide reservation for backward classes of citizen. And the two conditions of reservation are, as you have seen, it should be for backward classes, and the second condition is they should not be adequately represented. So these are the two conditions to enable the government to provide reservation for the backward classes. Now up to 1990, this was the reservation for the various classes. Scheduled caste 15%, scheduled tribe 7.5%. In 1990, the OBC 27% reservation orders were issued by the Government of India in the government jobs. So 27% was issued in the year 1990, and little later, after the new government was formed of the P.V. Narasimha Rao, there was a 10% reservation introduced for economically weaker sections. So persons with economically weaker section, this 10% reservation was introduced in the year 1991, and immediately after these orders were issued, particularly after the reservation for 27% was issued, people went to the court, and the famous judgment which considered whether the government was competent to issue reservation orders for OBCs under clause 16. This famous judgment is known as Indra Sawhney versus Union of India. So the judgment was delivered on 14 November 1992, also known as Mandal case. Now it comprehensively considered all issues on reservation and finally gave a judgment which is a very lengthy judgment and almost a landmark judgment which every student of law or student of reservation must read. Now the Supreme Court considered the question whether, based on the Mandal Commission report, the government had issued had included some 3,000 castes in the list of other backward classes other than scheduled caste, scheduled tribe for 27% reservation, and that time it was a 9-judge bench, and it was the largest bench ever constituted to hear issues on reservation. And the Supreme Court gave a very lengthy judgment, but the main components of the judgment, in short, was it said that the criteria adopted by the government to identify the other backward classes was valid, and 7% reservation was held to be valid, because you can see that up till then the reservation for scheduled caste was 15%, scheduled tribe was 7.5%, and introducing this 27% we were well below 50%. It was total 49.5. However, the Supreme Court gave directions that creamy layer amongst the OBC will not be entitled to this reservation, and therefore asked the government to identify creamy layer from the OBCs. Mind you, not for the SC/STs, only from the OBCs. And the government in 1993 came out with an order of who will be creamy layer amongst the OBC. The Supreme Court also held that reservation in promotion is unconstitutional. However, it allowed it to continue for the next 5 years to prevent any kind of administrative chaos. So 1992 was the year of the judgment, and in 5 years, that means by 1997, reservation in promotions was allowed. Thereafter it should stop. This was the judgment of the Supreme Court. And Supreme Court also held, very importantly, that 10% reservation for economically backward is also unconstitutional. So Government of India's order of reserving 10% seats for economically weaker section of the society was held as unconstitutional, because Supreme Court said reservation cannot be on the ground of economic criteria alone. Supreme Court also recognized a 50% limit that was held in 1962, and that was the law in place since 1962 in the M.R. Balaji versus State of Mysore. So in MR Balaji versus State of Mysore, Supreme Court had held that no reservation beyond 50% can be allowed. So in Indra Sawhney, the Supreme Court held that this 50% reservation will be for every year. So a year was taken as one of the units, not the entire cadre, but the year. So each year it prohibits reservation of more than 50% vacancies of that year for scheduled caste, scheduled tribe, OBC put together. So Supreme Court held Indra Sawhney that Balaji was correctly decided and 50% will remain the limit. Now let us come back and try to recap of do the clause 4. As I was telling you that clause 4 the Indra Sawhney held is not an exception to clause 1. Clause 1 says there shall be equality of opportunity. So it said it is an instance of clause 1 because clause 1 itself according to article 14 that we have discussed, although it talks about equal opportunity, but equal opportunity amongst the equals. So classification, reasonable classification was allowed, and therefore it said clause 4 is not an exception but an example of clause 1, an instance of clause 1. Now there are three things here which we will again try to understand. Supreme Court said that backward classes, clause 4 means social and economic backwardness. So when we are talking of identification of backward classes, the main criteria will be social and economic backwardness, and therefore it held that any backwardness on economic criteria alone will not be possible under the Constitution. When it comes to the question of opinion, Supreme Court said that this opinion has to be formed by the state. So Supreme Court held the expression in the opinion of the state would mean formation of opinion by the state, which is purely a subjective process. It cannot be challenged in the court on the grounds of propriety. However, now this is important, however, if the opinion suffers from the vice of non-application of mind or formulation of collateral grounds or beyond the scope of statute or irrelevant extraneous material, then that opinion is challengeable. So it was within the Supreme Court held that the court can go into the question whether the opinion has been formed based on cogent data, collateral evidence. Finally, the third part was adequately represented. This was again, as I told you, Supreme Court held that not adequate means reservation should not be more than 50%. Now this was the recapitulation we have very quickly done of clause 4. Now if you remember, if you quickly go, there were two things here. Reservation in promotion was unconstitutional. This is what the Supreme Court held, and it also held that 50% limit will remain. Now to neutralize the portion of the judgment of the Indra Sawhney where it held reservation in promotion is unconstitutional, the government amended the constitution and brought a bill in the parliament and inserted clause 4A. So it was a constitutional amendment by which clause 4A now enables reservation in promotion. So 4A is just like 4 is an enabling provision, and it says nothing in this article shall prevent the state from making any provision for reservation in matters of promotion. The words with consequential seniority was inserted by an amendment in 2001. Although this amendment was given retrospective effect from 17/6/1995. Now let us try to understand what happened and why it was included. This was included because in one case, in Virpal Singh Chauhan case, Supreme Court had held that reservation, a scheduled caste person promoted by virtue of reservation will not get his seniority from the date of officiation. And a general candidate who was senior to him in the lower post, when he will be promoted later, he will regain his seniority. That means he will go above the scheduled caste or the scheduled tribe employee promoted Let us take an example. Let us take there is an organization where there is a post of upper division clerk, and in the year, let us say 2000, the year is 2000, there are two vacancies which have arisen. One is for scheduled caste and one is for unreserved. So when you check up the reservation roster, you find one is for scheduled caste and one is for unreserved. Now promotion is to take place from the feeder cadre. The feeder cadre is lower division clerk, and the promotion takes place from lower division clerk to upper division clerk. The seniority list of the lower division clerk is A, B, C, D, E, etc. Senior most is 1, 2, 3, 4, 5. So seniority wise, this is the seniority position. Now, in the year 2000, how many vacancies are there? Only 2 vacancies. So only 2 persons can be promoted. Now, who will be promoted out of these 5 in the rank of seniority? We can't decide unless we know if there is a scheduled caste person also. Now, let us assume that this Mr. E belongs to scheduled caste category. So, A will obviously be promoted, he is the senior most, and there is a unreserved vacancy. So, A will be promoted against the UR vacancy, and B cannot be promoted because the other vacancy is for scheduled caste. So, only scheduled caste available, first senior most scheduled caste available is E. So, E will be promoted against the scheduled caste vacancy, and these are the 2 persons who will be promoted in the year 2000. And let us try to visualize what will be the seniority list in the UDC. In the UDC, the seniority list up to 2000, there will be many persons sitting there, alpha, beta, gamma, etc., etc. So these 2 persons have been promoted in 2000. Their names will come. First, Mr. A's name will come because between A and E, A is senior, and then we will write the name of E who is SC. So seniority list of the UDC will be like this: 1, 2, 3, 4, and maybe in the UDC this man A's seniority is at 19 and this man is 20. Am I clear? Very simple to understand. But since the Supreme Court said that E scheduled caste will get his seniority as we have shown correctly, but if later B and C and D are promoted, although they will be maybe promoted next year or maybe next to next year or maybe after 3 years, they will regain the seniority. They will regain the seniority above E. This is what Supreme Court said in Virpal Singh Chauhan. So suppose next year, let us write it here, next year in 2001, 2 vacancies arise again in the grade of UDC. 2 vacancies arise. These are fresh vacancies of 2001. And let for this keep of simplicity, we assume that both are unreserved. As per the reservation roster, both are unreserved. So who will be promoted? B and C. Please note that B was not promoted in the year 2000 because there was no vacancy for him. But in 2001, there are 2 vacancies, both are unreserved. So maybe B and C will be promoted. Now when B is promoted in the year 2001, the Supreme Court held their seniority will be above Mr. E because B and C were senior to Mr. E in the lower division clerk. So as per this Supreme Court judgment, the seniority will be after A, we will write the name of B here, then we will write the name of C here, and then we will write the name of E here. So other words, the seniority will be 19 will be A, 20 will be B, 21 will be C, and 22 will be E. Kindly note, A was promoted in the year 2000. He became a UDC in 2000. E also became UDC in 2000. And B and C became UDC 1 year later, that means in 2001. But as per the Supreme Court judgment, B and C will be senior to Mr. E. This was the result of the judgment, and therefore the constitution was amended, and it was the words consequential seniority were added to allow Mr. E to get his seniority as we had shown earlier. So as per the constitution amendment, the seniority of the UDC will be that what we have written 1, 2, 3, etc., etc. At 19, A will be there at 19, and at 20, B will not be there. At 20, E will be there. So the persons who were promoted in 2000 will stay together. Thereafter, persons promoted in 2001 will be, their names will be written. So name of B will come in 21, and 22 will, the name of Mr. C will come, because they have been promoted in the year 2001. Now kindly see, B and C will forever be junior to Mr. E. Although once upon a time in the lower post they were senior to Mr. E, but now B and C will be forever junior to Mr. E because of the word consequential seniority. So E will be promoted in the year 2000, and he will get his seniority, consequential seniority, from the year 2000 itself. 50% rule which the Supreme Court held was again neutralized by inserting clause 4B, and it said that any vacancy of scheduled caste, scheduled tribe which was not filled up in the previous year will be treated as a separate class of vacancies and shall not be considered together with the vacancies of the year in which they are being filled up. So the 50% limit was neutralized by clause 4B, and the promotion was neutralized by insertion of clause 4A. Kindly also recall that the Supreme Court had held that reservation for economically weaker section is not constitutional. So therefore, when 4 years ago reservation for economically weaker section was introduced by the Government of India in the government jobs, the government also inserted a new clause 6 which was not there in the constitution by 103rd Amendment Act, and it says nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any economically weaker sections of citizens other than those mentioned in the clause 4. So who is mentioned in the clause 4? As you know, in clause 4 talks about reservation for scheduled caste, scheduled tribe and OBC. So other than clause 4, that means anybody who is neither SC nor ST nor OBC but he is poor, he will get reservation under economically weaker section. So a scheduled caste, scheduled tribe or an OBC who is poor will not get reservation under economically weaker sections. Only somebody who is neither an SC nor ST nor OBC. So now we have a, so let us sum up of what we have discussed so far. Article 16(1) talks about equality of opportunity for all in matters of employment under the state. 16(4) is the reservation in direct recruitment for SC, ST, OBC. So clause 4 provides reservation in direct recruitment. 4A, which was inserted to neutralize the Indra Sawhney judgment, provides for reservation in promotion. 16(4)B says that 50% limit is not applicable on backlog vacancy. The 50% limit laid down in Balaji is not applicable on the backlog vacancies. Article 16(6) provides reservation for economically weaker section. Who is economically weaker section? Other than SC, ST, OBC. Article 335 talks about reservation in for SC, ST consistent with efficiency of administration, and the proviso says that relaxation or lowering of standards is permissible in promotion for SC, ST, OBC. So thank you very much. In the next video, we will talk about the scope and applicability of reservation and about caste certificates. Thank you.